Good afternoon, good evening, everybody, or even maybe good morning. Thank you for joining the first panel of the first annual conference of the Ukrainian Arbitration Association. My name is Anna Giar-Sashko. As Owen already said, I'm a board member of the Ukrainian Arbitration Association. I'm also a co-founder of Nash Arbitrage, one of the partners of this event. I have an honor to moderate today a panel with distinguished speakers. Today with Svetlana Romanova. Svetlana is based in Kiev. Also today with us, Maria Hauser-Morel, Dr. Maria Hauser-Morel. Maria is a counsel at Hennefeld and is based in Paris. Our next speaker is Professor Ziya Akinci. Ziya is a founding partner at Akinci Law Office and also a president of Istanbul Arbitration Center. Ziya is based in Istanbul. I'm also delighted to introduce our fourth speaker, Rytis Valunis. Rytis is the Chief Administrative Officer and General Counsel at the KN and also a board member at Baltpool. Rytis joins us from Vilnius. By the way, you can find more information on our speakers in the conference brochure. Today, the topic of our discussion is access to arbitration. From one side, this topic is widely discussed, and in the recent years, we have witnessed a number of initiatives undertaken by different actors aiming to facilitate access to arbitration and make arbitration more efficient. On the other side, many issues remain unresolved. Today, there will not be formal presentations, we will just discuss different questions, and our speakers, experienced arbitration users, will share their views and insights. At the end, we will have time for questions, so I encourage you to add your questions and comments to the commentary box on YouTube. Now let's turn to the first question. As our speakers have different background, had different experience with arbitration, my first question is, what is the first thought that comes to your mind on hearing access to arbitration? Maria, would you like to start the discussion?
Yes, of course, and thank you very much. I'm happy to be on this panel. To me, access to arbitration should be put in a larger context of access to justice. And of course, the first aspect of access to arbitration is the actual right to bring arbitration proceedings based on an arbitration agreement. But access to justice also means that once you start arbitration, it will actually lead to an enforceable award, and the actual process will be fair and efficient and led by an independent and impartial tribunal. And it's helpful to see that even on the arbitration ground, principles established by the European Court of Human Rights with respect to the access to state courts, including independent judiciary, fair process, and so forth, will be relevant in the context of arbitration. So not only the right to begin arbitration, but actually so that the whole process brings real justice.
Thank you, Maria. Ziya, would you like to share your view?
Thank you for the invitation, first of all. I'm very happy to be with you, even through virtual program, but I'm really looking forward to be in Ukraine again. And when I hear access to arbitration, Maria very wisely summarized. It reminds me two things. First, being able to take your case to arbitration, and that is very important. That involves cost and also involves positive, constructive interpretation of arbitration agreement. But also the second interpretation, as Maria correctly stated, is access to justice. And if I have only one word to describe access to justice in arbitration, I think impartiality, independence and impartiality of the arbitrator is very important. Thank you.
Thank you, Zia. Svetlana, what about you?
For me, the very first thought which comes to my mind when I think about access is obviously getting an end result and getting it efficiently, from the standpoint of costs, from the standpoint of time, and from the standpoint of effort which you put in actually getting that result. So I look from the result backwards to the beginning. So if I don't have a result in the end, there is no point in getting into the process, and the access in that particular case doesn't make any sense. So result is what is important, efficiency of reaching the result.
If I can just ask a follow-up question, of course, that covers enforcement, not only up until the award, but until you get the money.
Absolutely. Yeah. From the business, obviously, you know, the businessman, our commercial people, our clients, internal clients, we as in-house lawyers, we're working with them. They don't care about the process. They care about result. They care about when they get money. They care about when they ought to pay money if we're the debtor. So, and that is only possible when we get to the very end, including the enforcement.
Thank you, Svetlana. Ritis, what about you?
Indeed. First of all, thank you very much for inviting me and having a chance and opportunity and access to this distinguished panel today. So it's a big pleasure. And now going on and actually building on what was said already, I can only concur from business perspective, representing an energy infrastructure company and representing the in-house lawyers cohort today. I can only concur and maybe emphasize that to me, the access to arbitration means, first of all, efficient, of course, the ability to bring the claim, but then the efficient, impartial process, which results in a flawless, free of errors, any other deficiencies, enforceable award. And that's basically the great or a qualitative access to arbitration from business perspective. And from the client's perspective, who are actually the ultimate payers of all the bills that come out as a result of arbitration.
And what challenges do you face as a company in accessing arbitration or using arbitration, Regis?
First of all, I can think of quite a few not related with each other moments or circumstances. So the first thing is probably the jurisdiction itself, because if you do global business, and for instance, we have a company and business in Brazil, which is involved in infrastructure business, then the question, the question of starting point of question is basically, can you have all those features in that particular jurisdiction? And not only the process efficiency and so on, but also the enforceability of the award. So, and that way you can assess your accessibility as such. So that's first thing, the jurisdiction and the interacting jurisdiction where you do actual business. Then efficiency element. So is the institution or the basically the forum where you agree to delegate your arbitration is efficient? Does it have efficient procedures and is also able to, let's say, to gather all together, organize the setup, and also have a experienced and not very busy or extremely busy arbitrators and all necessary personnel to organize the arbitration procedures efficiently. And probably the third thing it goes down to the expenses and the money aspect of the access. So basically, how much does it cost to start arbitration, to run the process, and arrive at the enforceable decision and award? So this does also matter because for the smaller amounts of, let's say, possible claims and contracts, you don't, the expensive arbitrations and the prominent institutions might not be accessible from the business case point of view, meaning that you may not be capable to actually get the financing or from the CEO to go into that case and hire competent lawyers.
Oh, but can I add, because this is the job for a lawyer to do at the stage of concluding the contract.
Mm-hmm.
So you don't think about it when you go to the arbitration. You think about it when you conclude the contract. And this is where and when you make that choice. So.
Indeed. Well, the reality is that usually, based on my experience, and I've been examined and scrutinized clauses in the commercial agreements, because the companies, the partners, businesses don't care much about the litigation clauses and dispute settlement clauses, and it's always about the commercial provisions, the prices, the terms, obligations, and so on and so on. So it does really depend on the smartfulness of lawyers involved in the making of the contract. So I would say if you have good lawyers, you would always pay attention and you would always take care, even though your CEO or the board don't care about it. So I don't know if I managed to answer your question, but that's rather the.
I mean, it's your experience.
That's my experience.
Yes. Svetlana, what about you? What are your challenges?
Well, my only challenge is to be wise enough and visionary enough to predict how a particular contract will end up in the end, whether we will have a dispute, we will not have a dispute, what kind of possible claims we might face, whether those claims are worthy of litigating or arbitrating, and if the choice is in support of arbitration, then which tribunal we go, which institution we use, and so on and so forth. I think this is the hardest part, and that is the job we should do as the lawyers. And if you're a good lawyer, you can do that prediction, and then you don't have any challenges in actually getting your case arbitrated and getting a successful result in terms of cost and time and efficiency. So that's where it starts.
Okay, thank you, Svetlana. So we've heard about business perspectives. Now let's turn to institutions. I think many of our audience know that Maria worked as a counsel at the ICC for many years, so she's quite experienced. We cannot say a representative of an institution, but know how it works. And Zia is the president of the Istanbul Arbitration Center, facilitating access to arbitration and facilitating providing access to arbitration.
Thank you, Anna. My connection sometimes suspends, so but I think I got the role of institutions, you mean, right?
Yes.
Yes. Sorry, there was a little blank. Yes, indeed, I do think that institutions have a role also to increase predictability that Svetlana mentioned. So the institutions are there to ensure access to arbitration in a way that they will clarify how to get there and what's the procedure in order to start arbitration and in order to run an arbitration proceedings. That means that the institution should be available for answering any questions that the parties may have, but also ensuring that arbitrators are independent and impartial, a point that we mentioned in the beginning. And as many of you know, for instance, ICC has a very strict and thorough process whereby the institution makes sure that the arbitrators who are put in place are independent and remain impartial. The institution may also put in place a case management that will ensure that the arbitration process, is actually efficient and fair to both parties. That requires, of course, that somebody will follow up on the case all the time, as it is done at the ICC. And another point, going back to predictability, is publications. And here, for instance, ICC, but also other institutions regularly publish information about statistics, but also excerpts from procedural decisions. And soon ICC will publish awards. And that will go to the predictability in terms of, if I start an arbitration, what are the chances? I think there will be more examples out there in the air. And I think for the users, the predictability will increase with of awards. And just to add that in addition to institutions, I think associations such as Ukrainian Arbitration Association do have a role with respect to access to arbitration, by talking about arbitration, making these rules more clear for the users, and making arbitration more friendly. So I think it's not only institutions, but also local associations, because to make sure that arbitration is understood locally and takes into account local specificities. So that will be my long answer to your short question, Anna.
Thank you, Maria. It's very interesting and insightful, and I really looking forward to read the awards, the new awards. Zia, would you like to add something?
Yes, I think the arbitration institutes play an important role to access the justice in arbitration. But first of all, transparency is important because not all the parties are experienced in arbitration, so they should know the practice of the institute to the extent possible. There may be a secretariat guide or some explanation, so that makes arbitration transparent and predictable for the users. Also, appointment of arbitrator is very important because our expectation is the arbitrator should be independent and also available. So the institute make sure that the arbitrator will be available and independent for this particular case. Also, in practice, the institute should be responsive when the parties ask any question, make any application. There should be a reasonably fast answer to the users, to the parties. Sometimes, unfortunately, I experience as a party representative, I called some of the institutes, and I mean, there was no response to the phone. Practically, the phone rings, but there is nobody to respond. Or you write letters and you don't get any answer. Or you write a letter, you say, when can we pay us, very polite whenever it is ready, etc. So these are really very concerning for the parties, because if you don't know the institute and then if you get this kind of reaction, how can be sure that you are going to get justice in arbitration? Also, one should not forget small claims are also important. Institute has a significant role to survive the small claims. Therefore, the institute can offer fast-track arbitration or specially designed arbitration for the small claims, because an amount may be small for one party, but for the other party, this amount may be very important. So you cannot simply ignore that, oh, comparing to the other giant arbitration, this amount is small. I think one should not ignore small claims as well as an arbitration institute. Thank you.
Thank you, Zia. That's true that one of the impediment to access to arbitration is its cost. And my question goes in continuation of the discussion, of course. In terms of justice, sometimes we deal with complex arbitrations, sometimes with more straightforward arbitration, and different cases have different amount at stake. What are the criteria? What do you think? Where should be a line between litigation and arbitration in terms of access to justice? Ritis?
That's millions, and I see plural, millions euros or dollars question. And I believe that there is no single correct answer to that. Having said that, from my company's perspective, we basically want to have arbitration when we have, and that's usually as the case, the investment and infrastructure projects that exceed several million euros. So double digit, that's probably the threshold to think about arbitration. And with that in mind, we normally, depending on our partners and their origin and state of origin, the recent practice was that we would trust the Stockholm Court of Arbitration as a convenient forum and the one with good reputation and track record. So this is the first threshold. That's one thing. And then depending on the arbitration clause and whether you can basically receive and use the expedited procedures, in some cases that the threshold was even lower. So I can think of, I don't know, few million possibility to arbitrate. But normally what happens when you have a small claim, let's say a few millions, parties are sort of reluctant to go and incur all the expenses, and there is more motivation to negotiate and settle differences amicably. So that is my takeaway. Otherwise, then again, a layer is the jurisdiction of your partner, and basically, if you do business in different jurisdiction, it is a default rule to choose the arbitration provisions, the dispute settlement, delegated arbitration as a rule, because you may not trust the national courts because A, you are not experienced with national, let's say, case law of the Brazil. B, you still want to have some sort of control over the dispute by using your rights in arbitration. That's the appointment of arbitrator, and then have a certainty and clarity when it comes to organizational provisions, how the dispute is handled. So I think these are two very important aspects that we consider. But there is no. So every time you look at it as an on ad hoc basis. So you have a contract, if you have. But I mentioned that normally business and boards tend to ignore, they don't care. So be sure that you have smart and experienced lawyers so that they care of those provisions, because sometimes this bad word happens in reality.
Okay, so the lawyers are very important, and smart lawyers are even more important.
Indeed.
Svetlana, how does it work for you?
Well, for me, first of all, we tease ourselves with the fact that lawyers are important, but not the lawyers are important, but business people are at the top of the hierarchy. And as our clients, they play the tune and they order the music. And upon their appetite for risk and upon their expectations would provide, and also obviously I'm not saying that we should please them in all respects, but we should hear our clients and try to understand and predict how the situation might evolve and in which position we might end up, in a position of a defendant, or most likely will be in a position of a claimant. But I generally agree with Ritis. Each case is a particular case. You look at the situation and then you do the predictions, and this is where you make your choice which way to go. Obviously, all of us know about the alternative. Everybody's have a choice, or they go even a more complicated way and say, okay, claims, above that amount go to arbitration. If claim is less than to litigation, but this is, again, not a magic wand in a way, because you need to be careful with these types of clauses, and this is where you need good lawyers. That's absolutely agree on that, to draft those clauses properly, and then not to have a conflicting situation where you disagree on the forum, and you are in a deadlock with the other party in terms of where you should go to resolve your disputes.
Thank you, Svetlana.
Anna, can I add
Of course.
short points? First, that small cases are not necessarily straightforward. And failing the party settlement, we should give them access to justice, whether it's litigation or arbitration. The trick is that this justice should not be too expensive, as it is said. So that is why also arbitral tribunals, not only institutions, by creating special procedure for claims below 2 or 3 million or whatever, not only institutions, but also arbitral tribunals should make sure that they do not treat each case in the same way. So you cannot have, for a case for 1 million euros, 3 rounds of submissions, document production, and so on and so forth. And unfortunately, speaking from my experience at the ICC, some tribunals are tempted just to reproduce the same process in each case. So I think that the responsibility is not only on the smart lawyers, but also on smart arbitrators to make sure that the procedure is adapted to the complexity of the case, so that even in these small cases, for maybe not as much money as they would have spent otherwise, the parties can get justice. But that requires a lot of preparation. I think early preparation is from the tribunal, and maybe Zia, who's more experienced arbitrator than I, would say how beneficial it is for arbitrator to be at the desk early on and know the case early on in order for the procedure to be adapted to the needs of the case. And that may require, for instance, the solution may be in a small case that the tribunal early on provides a preliminary review on the case and then the parties settle. But the tribunal should have an open mind and think about how to best render justice to the parties.
Thank you, Maria. Zia, would you like to add something from arbitrator's perspective or the counsel perspective?
Yes, I would like to. I mean, I echo all the arguments that my fellow panelists already expressed, but I just would like to make point. It is not exactly possible to predict whether the case is going to be small or big. You may have a big contract, but at the end you can have a small dispute, or you can have a reasonably small contract, but you may ask loss of profit for 10 years, then suddenly you can have a reasonably big contract. So therefore, I think arbitration industry should offer flexibility to the parties. And also in some cases, even if the amount is small, arbitration may be the only efficient way to resolve the dispute because of neutrality, because of enforceability, etc. So at the end of the day, the parties may need arbitration, may need to access to arbitration. So therefore, as my fellow panelists already expressed, the arbitrators as well as the parties should be flexible to adopt their case into the amount of the dispute, if necessary, save the cost as much as possible. And the rules of the institutes already allow this instead of three-panel arbitrator, instead of hearings, maybe even without hearing. So I think as practitioner, we need to be very flexible and reasonable to give the parties the right to access arbitration. Thank you.
Thank you, Zia. Maybe somebody would like to share an example when they preferred arbitration, but then they were disappointed and at the end thought maybe we should choose the litigation, or vice versa.
If I may start, in our arbitration community, let's be honest, we arbitrate and we love it. But in all our conferences, we talk about challenges of arbitration, and then maybe without any intention, we give the impression to people that arbitration has so many disadvantages, etc. So therefore, I jumped to this question. I would like to start the advantages of arbitration. Sometimes we have clients who have project and dispute in very difficult part of the world. And when we interview them without any merit, the first question we ask is, do you have an arbitration clause in your contract? Because if there isn't, and if the national courts has jurisdiction in this dispute, I mean, we say, I'm sorry, but it is so challenging. We cannot help you, and we cannot expect a reasonable decision, especially if the dispute is against a state or state party, etc. In many of the big project, construction project, that is the case. So therefore, I think we should promote arbitration as well as talking about the challenges. So therefore, my first expression is, in many cases, I felt that, oh, thanks God, there is an arbitration clause. And then I started to listen to the client, because it was possible to help to the client that there was a arbitration clause. But the other side of the coin, yes, I think we all have experience, including myself. Sometimes I say, if this was a litigation instead of arbitration, the cost would be much less, and then we wouldn't have very long hearing with so many witnesses, etc. So the court would resolve this issue easily, maybe faster and less expensive. But this is a very minority. In many cases, I am very grateful that there is an arbitration clause. Thank you.
Thank you, Dia. Svetlana, Ritis,
Maybe I
Maria?
can. I just briefly, I think for interim measures already, state courts may, in many jurisdictions, be a much more efficient way to get where you want. And sometimes just by having a successful application for interim measures, you can then settle the dispute on the merit. So I think the decision as to, sometimes you may want to go to state courts because they may be very efficient for a particular type of dispute.
Well, from my end, I may say that in my practice there have been cases where we challenged the existing arbitration clause, and we applied to the state courts, hoping that the other party would not object before starting the hearing on the merits. And there have been cases when the lawyers on the other side somehow did not do it, and then found themselves in the situations where they actually gave up the arbitration clause, and we actually, achieved what we wanted. So it's part of the strategy. And yes, we do find ourselves sometimes in the situation where we wished we had a different clause. Arbitration instead of litigation, or vice versa. And then if it was an arbitration clause, I say that there is a way to overcome it if the other party is not quick enough and witty enough. It's harder to do the other way around, obviously, because you need a specific consent of the other side to go to the arbitration instead of litigation. And those types of cases, I don't think I have anything at mind to share right now, but I think we made an attempt to specifically agree and to change the litigation clause to replace it with arbitration at some point. I don't think it was a successful one, but doesn't happen that way too often. I don't know, Ritis, maybe you have a different practice.
Well, gladly, I don't have a bad stories with happy end, not with a happy ending at the very end. However, I can say that the situations we use this term in basically daily activities, the near miss, when something when something nearly happens bad, but it ends up not happening. But then you can learn some lessons from that event. So I would say that now reflecting back, I can think of, let's say, moments in the arbitration cases when you have a bad feeling or the bad impression that things don't go the right way. So what I have in mind, for instance, the appointment of arbitrators, and well, in case of institutions, so you receive the message about the appointment, then you check the profile, the background, and then you develop some bad uh, feelings about the expertise, the competence of that particular arbitrator, and you're not sure if you will get the justice, let's call it, delivered, then again impartially and appropriately, and so on and so on. So that's one thing. Sometimes the competence. Sometimes it's about the speed of communication. Then again, if some procedures get delayed, and sometimes it's on the contrary. Actually, I have much better impressions and experiences than worse impressions, where you have the attempt to abuse the procedural rights by uh, opposing party, and then you have a kick or punch by the institution and the chair to that party to speed up and actually to have the award rendered within reasonable time. So I would say that no clear answers or misbehaviors of the arbitration as such. But then again, we are all human beings, so sometimes you expect, maybe you have higher expectations. Sometimes those expectations are not met in some stages. But then if you have the award rendered, issued, and it's fully enforceable, and the best thing is to have an award rendered which is enforced or met, complied with by the by the opposing party without need to go to national courts and enforce it. So that's probably that's the sign of the quality of the process, the award in itself, and maybe the reputation of the institution and the tribunal. So this is my maybe a little bit vague reflection, but that's the way it goes. And maybe I can add on the top that my experience is that when you do business and you have a new partners coming to Lithuania, in this case, because I live in Lithuania, or you go abroad, normally the default presumption is lack of trust. You don't trust national local courts because you're not familiar with the environment. If you spend more time doing business and doing business in that particular jurisdiction and vice versa, I think businesses, they develop this trust, and that way they tend to trust the local courts more, and then maybe delegate or redraft, basically reschedule, redelegate some of those potential disputes if they arise to national courts. So this is my impression, but this is familiarity, maybe this aspect. The more we are familiar with something, the more we trust something. This is a psychological human nature effect, I think.
Thank you, Ritis. I think also what is important is also transparency of court decision on the enforcement and setting aside of the award in a specific jurisdiction. And today we will have a special presentation on the analysis of statistics in Ukraine. And I know that different countries, different initiatives, we can see now just to promote the enforcement and promote their countries, they conduct this analysis.
I think it's a very good point, Anna, because I think it's just to say that access to arbitration, you cannot have a full access to arbitration without the support of state courts. So I think the point that you made about the pro-arbitration state courts, I think it's a very valid point.
My next question is about access to arbitration, but from another perspective. We all know that now there are more and more LLMs on how on arbitration. There are more and more law firms, lawyers wanting to practice arbitration, and the environment is very rich and varied. And this question goes to Svetlana and Ritis. What criteria are important for you while choosing a law firm to represent your company in the arbitration proceedings?
Ritis, do you want to go first?
That's the biggest secret. Of course, I can go first. I think I can start from a from the opposite side and deny all the stereotypes that it's all about the competence, of course, the track record, the academic works, and the possibility to check your lawyer's competence, the ratings, rankings, international, different those indexes and so on. So this is really important. And again, the quote, something big and sounds so sparkling. I'm just joking a little bit, but I think what is really important is the trust established and developed in course of your work. And normally you choose the law firm which ideally which you do business with on a daily basis for commercial transactions, for M&A, for any other kind of activities. And then if you end up in a dispute, that would be the first point of contact to go. So provided that they have the arbitration or dispute settlement or litigation division in the law firm. So that's first point to consider. It's really a human nature, again, a trust. And then I wouldn't be probably, and it wouldn't be unfair to say that, guys, the arbitration, it's the world of the community. So it's the insiders community separated from the rest of the world. And like a secret club, someone see people, this is mafia. And of course, it's when it comes to the decision, what to choose, who to choose, and so on, you always think about who you know, whom you met, whom you hear. So these conferences, they play a great role in helping to make new connections, getting to know people, and then choosing the best professionals, because I'm certain that this conference attracts the best people in their respective fields. So this is a little bit of pleasing maybe and sweetening, but that's the way to go. You look for someone whom you can trust and whom you know.
Thank you, Ritis. And you also said earlier today that usually as the seat of arbitration, you go to Stockholm. Do you have a similar choice for arbitration? You prefer to work with the law firms, I don't know, from the UK or France or Switzerland?
So it's always about, I think the chosen law is important. And in my company's case, in the energy business, for some reasons, and shipping business, the default applicable law is England and Wales law. And that way you need someone who is knowledgeable. That greatly limits the possible choices. And of course we look...
And increases the cost.
And increases the cost, skyrocket. And since you mentioned, I remember I was in a conference exactly 10 years ago in New York, arbitration conference, and the New York lawyers were talking about the expense of arbitration, and they were saying, well, the clients and people accuse us of being expensive lawyers and arbitrators. They are much more expensive than us, so it's not fair. So I would say, of course, money matters. But then again, I would say that, I am a millennial already, so you have this natural tendency to work with people from your generation, I guess, and it's becoming. And of course, the diverse team are really important. So from my point of view, I tend to look for law firms and lawyers who are rising stars and not only the matured stars, because I believe that the diverse teams composed of both rising stars and really experienced lawyers, matured lawyers, proven lawyers, that way you can really get the energy, the necessary dynamism, the experience, the know-how, but also this, maybe the hunger to win and hunger to do everything that's up to you and maybe go this extra mile. So I trust in the companies and law firms that I diverse, and they have lawyers who are growing, who are becoming and they are already rising stars and really determined, and someone with really track record proven experience, but maybe to act more in this advisory coaching role and so on are really, really high. I can assure that if you have only superstars, this is the best way to spend all the the external lawyers budget in the company.
Thank you for your honest answer. Svetlana, what about you?
Well, I'm sitting, I was hearing Ritis and I was thinking about, it's like, okay, Ritis is a millennial, so I feel old. Anyway,
no offense.
I'm just kidding. Forever young and forever energetic. So for me, the choice of a law firm is, again, it's always a subject of an analysis in each particular case. And our company, we do not have a pre-selected panel. We don't have any preset preferences. We're normally opened to any choice we might have and we might get in each particular case. And how we do the choice. First of all, for me, there is a high importance is placed at the correlation between the case, its value, complexity, jurisdiction, forum where it is going to be resolved, and the law firm which we entrust with this case. Because if it's a small claim, if it's a simple claim, I don't think a Magic Circle law firm is necessary. Yeah, I can do it much more efficiently with going down the tier. If vice versa, it's a complex case, multiple parties. Obviously, you need the best legal support you can get for your money, and this is where I look only at Magic Circle. So this way of thinking provides me with a variety of law firms which I'm working with in each particular case. And it's true to say that we work with big law firms, with stars and known personalities in their fields, and with the smaller law firms, local law firms, which can provide us with a tailored, very local advice we need in each particular case. If correlation analysis is done properly, then the cost is proper. The quality should be for the cost should be acceptable. The efficiency of the process, I think, would be also on a proper level. So that's how we go about it.
Thank you, Svetlana. I'm curious to know, how do you see the changes in Ukrainian market? How it changed in the last, 5-7 years for you?
In respect of, well, there are lots of changes in
Of
Ukraine
water,
generally,
of water.
and
Because I know, traditionally, for many years, not only in Ukraine, in many countries, for big cases, you have a leading counsel, international law firm, and a local counsel. And I understand that now there are more and more businesses using local law firms without just maybe as an external consultant for very limited questions. But otherwise, there is this move to use more local law firms than international.
Again, speaking from my own experience, and this is where I completely agree with Ritis, you need to work with the person you trust. So normally then talking about Ukraine and about local law firms, no, law firms in Ukraine, not local, but law firms in Ukraine. I do not, my way of thinking is not to think about a law firm. I think about a particular personality. I think about a particular lawyer I want to work with, and it doesn't matter for me where that particular lawyer is employed at the moment, because lawyers tend to change and to shift between law firms. I'm looking at a particular specialist, at a particular lawyer whom I can trust, who I feel comfortable with, and who I can call in the middle of the night if I need. Yeah. So for me, here in Ukraine, if I'm to choose a lawyer here in Ukraine, doesn't matter whether it's an arbitration or something else, I always go for a name, not for a law firm.
Okay. Thank
Anna,
you,
can I have a brief follow-up comment on that, if we have time?
Sure, we have time.
I did notice that in the last years, about 10 years when I was at the ICC, more or less, parties from Eastern Europe 10 years ago were using much more Western firms because they trusted them as, as he said, there was this mafia. And I think right now in Central and Eastern Europe, you have so much more expertise, and you have local firms that have really a lot of expertise, quite comparable to the expertise from London and so forth. And so what we have seen more and more in Central and Eastern Europe is that you have a pairs of a local counsel and an external counsel, but I think more and more local counsel who are very experienced. So I think it's no longer the mafia that we used to have 10 or 15 years ago. I think this has really changed in Central and Eastern Europe. I think we can be proud of ourselves in this regard.
I can tell you that I'm using a local law firm and a particular partner or particular local law firm for an international case right now. So that's happening as we speak.
This is great. I left Ukraine more than 10 years ago. I work with Ukraine. I go back to Ukraine very often. And it's like every 2-3 years, I see this very good improvement in arbitration and in our community becoming stronger and stronger.
So Anna,
also
you
in terms of language skills.
Yeah.
And also in terms of language skills, I think access to arbitration is possible if people speak English, because many arbitration cases are in English. And I think in Central and Eastern Europe, the English is now spoken. Matter that.
My connection was bad. Okay, before we turn to the question from the audience, I have a question to Maria. His first appointment or to develop his profile as an arbitrator, can you give a couple of advice?
Yeah, my connection was bad again about how to get the first appointment, right? And
not the first, but to build as arbitrator. What is important? Is it important to be a speaker very often, to publish? I don't know, to write a PhD, to attend all the conferences in the region?
Yes,
I'm joking.
I do not. Yes, I don't think writing a PhD is an enjoyable activity, but I don't think it brings cases. Speaking at conferences doesn't bring cases. Building relationships with people may bring potential appointments. At least that has been the case for me, because for arbitrator appointments, you need, like for counsel appointments, trust of people. Riti said Svetlana will not appoint somebody who they may have heard at the conference, who is a good speaker, but somebody who has a good reputation and knows how to read law and who understands business. And I think a good arbitrator as well needs to really, or potential arbitrator needs to not only be an expert in arbitration, but also understand business and economy. And I think many young people start to understand that, and they even study economy in addition to law, to have that business approach, not only the legalistic approach. So I would say that building a network of contacts is important. And then once you have your first case, work and be prepared and really make sure that the quality that we've talked about that it's highest quality ever. So that these will be my initial reaction. That will be my initial thoughts. Yeah.
Thank you, Maria. Zia, what about you?
Of course, knowing arbitration is important, but also if you want to be an arbitrator, you need to be an expert in a substantive law, such as construction law, corporate law, transportation law, finance law. There should be an expert area that people would recognize your expertise and appoint you as an arbitrator. And this question is being asked me very often because when we try to promote Istanbul Arbitration Center, many fellows ask, how can we be an arbitrator? And my humble advice to them is they should draft arbitration clause in their contract as much as possible. That will enable them to attract more and more arbitration cases as an attorney, as a lawyer. And then when they are experienced in arbitration cases, sooner or later they are going to be appointed as an arbitration. So in fact, our colleagues' arbitration career is in their hand. The more arbitration clause they draft and in more arbitration cases they act as an attorney, they will increase their chance to be an arbitration expert. Thank you.
Thank you, Zia. I also heard many stories of arbitrators who started their career like in the 90s, in 2000s, that for them becoming an arbitrator or starting practicing arbitration was just a chance, that they went somewhere, they met somebody, and just, oh, would you like to work on this arbitration case? And just, yeah, let's try. And for you, do you remember how you were appointed as arbitrator for the first time? Whether it was a coincidence or just a chance?
I guess you are asking this question to me, Anna, but I'm happy
Yes,
to answer.
yes.
Thank you. I did my PhD on arbitration, and then I was so eager to be a secretary of an arbitration tribunal. And I made an application to so many arbitrators and to so many professors of mine. But as you said, it is a question of chance. Unfortunately, I couldn't get the opportunity to be a secretary of a tribunal. But then suddenly, I was appointed as an arbitrator in a reasonably small case, and then another one, and then another one, and then it continues. So I fully agree. It depends on chance. You know, sometimes you try very hard, but it is very difficult to get the first appointment. But the only thing is, the more you involve in arbitration environment, the more you involve in arbitration cases, whatever your capacity is, as a counsel, even as a secretary, it is very important to be in the club. And then sooner or later, when you get your appointment, you would feel comfortable. And if you have luck, then you may continue.
Thank you, Zia. So the conclusion is just to be patient also, that just to wait for a chance, work hard and be patient. Now let's look at the question from the audience. We have a couple of questions. Okay, one question from Evgeny Vasilchenko. Greetings from Paris. Many thanks to the distinguished speakers for the insightful discussions. My question is to Svetlana Iritis. From the perspective of business, would you endorse the trend to publish arbitral awards by the institutions, and would you be willing to have your awards published? If so, on what terms?
I can go first. My answer would be short, no, because that would violate one of the principal reasons why I want to go to arbitration. Yeah, it's a confidentiality of proceedings. It's a confidentiality of certain facts, certain issues, certain moments. And obviously the arbitration award is quite, normally is a quite detailed document, which and lists a number of things which I don't want to be publicized. And my initial thought would be to keep them private, out of the national courts, and to keep them confidential. So no, absolutely not. I'm a strong opponent of the arbitral awards being published and publicized, because that would actually defeat one of the main privileges of having an arbitration in a particular case.
Thank you, Svetlana. Rytis?
My answer would be, it depends, and it doesn't say a lot. So maybe I just want to add a couple of practical nuances that I've had at my work in this company, and being the fact that my company is listed on an exchange. And if you are listed, you have quite an extensive list what to announce on the exchange to the investors, because any dispute may be treated as a material event for the investors. So there is an obligation to announce and to reveal, and it's kind of a struggle. So this is first point where you have to reveal the facts. You go into arbitration, then whether you should reveal the claimant, the parties, and so on. And this is first, let's say, burden, difficulty that you have to solve, and you can't avoid basically announcing and revealing. And in the past, I found it quite challenging, because you have this burden, you have this the confidentiality, the secrecy in a good way, but you have to announce. And this was a sensitive issue. We had a couple of cases. So even in those instances, even the mere fact is a pain. So that's one thing. And then another case and example is that when you have the award rendered, and you have your lawyers who represented you willing to go into the world and basically scream out and declare that they did assist you, represent you, and here is the victory, that and that, and with the details that and that. So then again, in a couple of instances, I had to say no, or at least wait and be really careful with what is being actually announced. So I would say, for the sake of public good, we might consider publishing maybe summarized awards with no confidential and commercial information. That would be the possibility. But then again, every case is a headache for lawyers, because you really have to go through and see what's permissible and what's confidential and what is not appropriate to be announced from business perspective. And there is no criteria list. So it's a difficult question, but if that helps to develop and promote arbitration, and if that helps to improve the access to arbitration, I would be friendly and supportive of some sort of summary publication mechanism.
Anna, although the question of Evgeny's question was not to me, can I jump in?
Just very quickly, because we have other questions.
To say that publication, of course, unless the parties object, increases predictability that Svetlana mentioned. So unless the party objects, I think publication will increase access to arbitration, meaning that the parties will be able to predict a little bit more the success.
Thank you, Maria.
Indeed.
Okay. The next question. I have a question concerning mediation, especially in terms of cost efficiency and time efficiency. What do the panelists think? Also in line with Singapore rules and new ICC and ICD MEDAR rules. Also, would mediation be perceived differently in terms of culture? For example, US parties are generally more familiar, while, for example, mediation as ADR is relatively new in society. Who would like to take this question?
I can answer, Anna, if you don't mind. Because in Turkey, mediation is very widely used as we compulsory mediation before any commercial cases. So therefore, in our domestic practice, we use mediation very often. And in international practice, because I involve in construction cases very often, as counsel, I quite frequently involve mediation. Especially in construction contract, it may be a good solution before arbitration, at least to settle some of the cases. And there are really very good expert mediators who can facilitate the settlement between the parties. But one problem with this is the counsels should prepare the clients very well before the mediation. So mediation is not to argue against each other, but just to cooperate to find a settlement. Sometimes you don't see this approach and it is impossible to have the settlement. But if both parties are constructive, indeed it is a very efficient way to resolve. But having said this, I have to confess that in my experience, I mean, it is not very realistic to expect all the disputes, most of the dispute can be resolved through mediation.
Thank you, Zia. Does
If
somebody
I can
want
just
to
add
add?
that you see that mediation in Central and Eastern Europe is not as successful as in some countries, but there have been mediations, and at the ICC, for instance, level, you see that mediation has more and more success. And I think last year during the pandemic, parties were trying to mediate a little bit more, and many have been successful in that. So I think that it's also there's a future for mediation as well.
Thank you, Maria. Rita, Svetlana,
I can
any
only add
source of
that
mediation?
okay, I can only add that only from Lithuania's perspective, that mediation is the trend and popularity is growing up, and it's quite substantially, and it's now growing up between businesses as a mean of this dispute settlement. So again, I would say that maybe for small claims, I would be more favorable of mediation. And then again, if you have complex questions, you need an expertise. As a professor just said, you need an expertise, the knowledge of substantive law, this preferably. So I think that's the difference for choice.
Thank you, Rita.
Well, I'm more skeptical out of all of you. My position is there is nothing in between. It's either, you know, we are able to communicate with the counterparty and agree on something, or we cannot. And I'm very skeptical in believing that a third party, outside third party, can bring can bring the situation to a solution, especially when it's big company, with lots of people involved, lots of commercial interests involved, and so on and so forth. So normally, at the same time, I agree that it's always best to agree and not to litigate or arbitrate. That's obviously my first advice and my first question, which I ask my client, my internal client, saying, can we settle? Can we agree? Is there room for negotiations? Is it that bad? Do we really need to go and start the process? In many cases, and this is also true, they do settle. They agree because they want to keep the business relationship going. And we are in the sphere of steel production, and our customers, obviously it's a very tight market, and we're fighting for the customer base, we're fighting for the markets, and we are very much client oriented in this respect. So we will lose money, I would say, faster than we will lose a good client. So
thank you, Svetlana.
But I don't think we will turn to mediation to do it. The commercial talks rule in this particular case.
The time flies, and unfortunately, we have to finish our discussion. Thank you very much for your honesty, for your time, and I really hope that we will be able to meet next year, or maybe even this year in Kyiv.
Thank you very much, Anna, and thank you, everybody.
It's been a pleasure.
Well, I would be very, very happy to greet you in my home city. So even if you are traveling not for the arbitration conference but on some other matters, please give me a call. And thank you for the audience bearing with us and our not so fancy comments. I'm sure you knew more or most of what we said. And thank you, Anna. It was a pleasure seeing you again.
Thank you
very
and
much.
stay safe.
Goodbye.
Bye.